Judgment in the matter of CCC by her mother, litigation friend MMM, against Sheffield Teaching Hospitals, NHS Foundation Trust.
In this appeal, the Supreme Court is asked to decide whether a child claimant can recover damages for loss of earnings and loss of pension during the years in which she would have been alive if she had not suffered a reduction of her life expectancy as a result of the defendant's medical negligence. Damages of this kind are known as lost years damages. The claimant, who is a young child, suffered a catastrophic brain injury during her birth. As a result, she's not expected to live beyond the age of 29. The defendant, NHS Trust, runs the hospital where she was born. It has accepted responsibility for the negligence which caused her injury. At the trial, the parties agreed that if the claimant had not been injured, she would have enjoyed a normal life expectancy. They also agreed that she would probably have gained GCSEs and other qualifications leading to employment, that she would have worked until the age of 68, and that she would have received a pension for the remainder of her life. Her loss of earnings to the age of 29, her current life expectancy, was agreed. This left the question of financial loss during the years of life which she has lost. Two decisions of the House of Lords, when that was this country's final court of appeal, establish that lost years damages are recoverable in English law. Such damages are commonly awarded to adult and adolescent claimants who have suffered life-shortening injuries. However, they have not been awarded to child claimants because, in another case called Croke and Wiseman, the Court of Appeal held that lost years damages could not be recovered where the claimant is a young child. The parties in this case agreed that the trial judge was bound by the decision in Croke, so he could not award the claimant any lost years damages. In her appeal to the Supreme Court, the claimant argues that the decision in Croke should be overruled because it is inconsistent with the earlier House of Lords decisions. By a majority, the Supreme Court allows the claimant's appeal and holds that lost years damages can be recovered in cases where the claimant is a young child, just as they can in cases where the claimant is an adolescent or an adult. In Croke, the majority of the Court of Appeal held that lost years damages could not be recovered by claimants who were injured as young children because they did not have and never would have any dependents. The majority of the Supreme Court holds that this is inconsistent with legal principle and with the earlier House of Lords decisions. There is no basis in our law for drawing a distinction between claimants with and without dependents. Damages are designed to compensate the claimant for her own loss, not anyone else's, and the claimant's right to damages does not depend on how she might choose to use them. So whether she has dependents is irrelevant. It follows that the reasoning in Croke was incorrect. However, the defendant argues that Croke should be upheld on an alternative basis, namely that assessing lost years damages where the claimant is a young child is too speculative. The argument is that because comparatively little can be known about the future prospects of a young child, in this case somebody injured as a baby, the court should refuse to speculate about their earning capacity. The majority of the Supreme Court rejects this argument for the following reasons. First, damages for loss caused by negligence are intended to place the claimant in a position she would have been in if the wrongful act had not been committed. That general principle applies just as much to a claimant who is injured as a young child as it does to one who is injured as an adult. So the court cannot properly exclude the recovery of compensatory damages on the ground of the claimant's age. Secondly, the law recognizes that it's not always possible for the courts to quantify a claimant's loss with any precision. It's true that the financial loss caused by a personal injury to a child claimant can be very difficult to assess because there are many contingencies involved in attempting to forecast what the child's earnings were likely to have been if she had not been injured. But that's always true of a claim based on the loss of future earnings or loss of future earning capacity. Even in the case of an adult claimant, the future is uncertain and subject to many contingencies. That uncertainty is taken into account in the court's assessment. Where it's clear that the claimant has suffered substantial loss, but the loss cannot be precisely quantified, the court just has to assess damages as best it can on the available evidence. The difficulties of proof which the defendant has caused by inflicting a severe injury on a very young child should not be allowed to deprive the child of compensation. Thirdly, the difficulties in assessing lost years' claims by children are less severe than they once were as a result of developments in the law of evidence. One development is the use of actuarial tables to calculate how the award should be discounted so as to reflect the fact that the claimant is receiving a lump sum now rather than periodical payments in the future. Another development is the use of statistical evidence of average earnings as a guide to what a child claimant might have gone on to earn if she had not been injured. Claimants increasingly rely on evidence about a range of likely outcomes based on their family circumstances, such as the occupation of the claimant's parents or the qualifications and prospects of her uninjured brothers and sisters. This helps the court to make the best assessment it can of the loss suffered by that particular claimant. Fourthly, the courts routinely award damages to child claimants for financial loss caused by their inability to work during their lifetime. If it's possible for the courts to assess a child claimant's lifetime loss of earnings, it's difficult to see why they can't do the same in respect of the lost years. In the present case, for example, the available evidence has enabled the parties to agree the claimant's loss of earnings to the age of 29. There's no reason why the same evidence couldn't be used to assess her probable earnings if she had lived beyond the age of 29. Fifthly, if young children are to be excluded from claims for lost years' damages because their loss can't be precisely quantified, it's unclear where the line should be drawn between claims by young children and claims by older children and adults. For all these reasons, the Court of Appeal's decision in Croke is overruled. The Supreme Court remits the claimant's case to the trial judge for damages for the lost years to be assessed. The Court will adjourn.